Now I'm going to move on to estate planning, and usually one of the most common questions I get is, do I need a will or do I need a trust? Which document is going to get me where I need to be so that my loved ones are taken care of, right? In the most effective and easiest way possible. So there are some differences. A will and a trust essentially do the same thing. They allow the person who makes the will or the trust to determine who gets their assets and how. There are some differences. One of the differences is that a will is effective only on death. A trust is effective during your lifetime. And that can matter because a trust can offer some more lifetime protections. If you have assets, your home, and you throw that in a trust, it makes their management easier if something happens to you. A will has to go through probate court, and a trust avoids probate court. And we're going to go into that in some detail in the following slides. Avoiding court, as I mentioned in the beginning, in California is on the top of everyone's list of things to accomplish, and we'll see why. A will, for those same reasons, is typically more costly to administer post-death. A trust is often much less expensive, and typically it is. Okay, so probate. What's the big deal with probate anyway? So probate is the court-supervised process of administering a will or disposing of assets. It's public, it's expensive, there's no trust involved here. You need the original will. This is just an aside. This is a problem sometimes where an original will is destroyed in a fire or lost over time. Maybe there's a copy out there that someone has, the attorney who drafted it, or one of the kids, or one of the family members or friends, or loved ones. But if you can't find that original will, then there's a presumption that it was revoked, and then everything in that will doesn't happen, and the person is not accomplished. Probate is generally needed. So in thinking through, and I probably won't go into this in great depth today, but for those of you who don't have a ton of assets, right? You have your basic checking account and your savings account, your 401k, and there's not lots of money yet accrued in them. We might be able to avoid probate court through beneficiary designations. So this is just an aside that if any of you think you might fit into that category, I'd be happy to chat with you separately, and later if we have time go into it, but you might be able to skip probate court by jerry-rigging your account beneficiary designations. Okay. Non-probate assets, so this is what I'm talking about. Joint tenancy accounts, those skip probate court. Anything that's owned as a tenant in common, so not a joint tenant, that would have to be probated. Assets that are in your individual name would have to be probated. So it's a case by case, but typically speaking, if we're taking this in broad strokes, if you have a will, you generally are going to still end up in probate court. Okay, so the main reason why people want to avoid probate, the main reason is just cost, simply. Probate tends to be, and timing, especially right now with the pandemic. Courts, the probate departments right now, are closed essentially for still doing some types of filings, but you're looking at next year for hearing dates already. So probate's long, and it tends to be expensive. So fees in probate court are set by statute. And to give an example, if you had a home worth $1 million, which is not unheard of here in California, most average homes are. Even if you have a mortgage, your probate fees, if your beneficiaries have to go through probate court to get their house. So if you are leaving, if you have kids you're leaving your house to, or if you have a loved one you're leaving your house to, that person is going to have to go to court in order to get title to the home, even with a will. And for $1 million home with an $800,000 mortgage, you're going to be looking at close to $46,000 or more in court fees, okay, plus costs. So how do we avoid this, right? The whole topic of today, how do we get out of this? The main way is to establish a trust. So a trust is a legal fiction, essentially. It's a document that controls the management of your assets during your life and on your death. A revocable trust just means that you or the person who creates it can revoke it at any time. You're not married to this trust in your lifetime. You can change it up. You can get rid of it. And a trust essentially is, I mean, it's akin to a bucket or a vehicle. You put all of your assets into the bucket, and then your trustee, the person who manages it, they pour those assets over to your beneficiaries in a way that you designate in the document itself. Okay. And a trust can also be a tax planning tool. So right now, where super advanced tax planning is only needed for people who have quite a bit of net worth, because the Trump administration has increased tax exemptions. So the estate tax exemption right now is very high, and we'll talk about that. But a trust still can be used under certain circumstances to minimize taxes for the following generation. A trust is also a powerful tool, and I'm not sure, some of you have kids and some of you don't, so this won't apply to everyone, but it also applies if any of you have younger beneficiaries in general. So not just kids, but nieces, nephews, maybe you have a brother or a sister, and if that brother or sister was not around, you'd want their kids to step into their shoes. So in general, for younger people, a trust is a really powerful tool to plan for them. Without a trust or without a will, if you have a young person who's a beneficiary of your estate, they would receive a check for the full value of your estate or the portion that they're entitled to which they're entitled at age 18. Most 18-year-olds do not do well with a check for 300, 500, even $100,000. So what do you do instead? You create a trust, and this slide has a diagram of how a typical trust can be set up for kids. With all of this stuff, it really depends on your goals, and all of this is fungible and changeable. But here we've got the Knowles Family Trust. So Beyonce and Jay-Z decided that they wanted to establish a trust, and they're going to throw all of their assets into that trust. They put their house, and this is inaccurate because I'm sure they have many homes, but all their homes go into the trust. All their money, their music rights, their life insurance, everything is centralized in one place so that they, while they're living, the trustees, Beyonce and Jay-Z, can manage their assets for themselves. So during their lifetimes, it sits in their family trust. If something happens to one of them, a typical trust setup is that the survivor gets to keep all the assets and keep using them for the survivor's needs. This isn't the only way it can be set up, but this is one way to set it up, is that everything goes to the survivor. And the thought here is Beyonce and Jay-Z have kids, and they're both of their kids. So the survivor is going to take care of those kids. So there's no need to carve out any money on the death of one of them. We can just give everything to the survivor. The survivor can use what they need. And then when the survivor dies, then the money goes down to the kids. And here's where the trust planning really is powerful, is you can pool money for all the kids involved. And this doesn't have to be children. You can pool money for nieces and nephews. And you can designate a period of time when all of the beneficiaries or all the kids will be treated equally. So if Blue, Sir Carter, and Rumi are all really little at the time that their parents pass away, it probably makes sense to pool the money for their common benefit until a certain passage of time. So maybe until they're 25 or they've all gone to college. And during that time, we can distribute for their health, education, maintenance, and support. So Rumi, Blue, and Sir Carter can get support for anything they need. But until they're 25, it's all pooled into a common fund. Once everyone's sort of grown up, then it probably makes sense that each child, or if they're nieces and nephews, or each beneficiary gets their own pool that they can draw from. And so at that point, each one would have a separate fund. And then the person who makes the trust gets to decide, okay, do I want these kids to get chunks of change at any point in life? Maybe, at 30, they can have half the balance of their trust. Maybe they can terminate it at 35. Maybe we don't want a trust going on forever, right? And with the trust, let's say, so we're in a world where Beyonce and Jay-Z are not around anymore. Somebody else has to manage it. So they've chosen Kelly Rowland. So Kelly is going to be managing this for the kids. And the trust can allow for the kids to work with Kelly. So from ages 25 to 30, they're going to work with Kelly and learn how to do investments. They're going to learn how to do tax returns. So gain some of that financial fluency that Beyonce and Jay-Z were not able to provide to them. Okay. So this is just a sample of how a children's trust might work, or a trust for younger people. All of this changes. Every plan should be very specific to the situation, to the people who are creating it, and their wants and desires for whoever their beneficiaries are. So I mentioned in the beginning that I work a lot with blended families, and a blended family just essentially means two people have come together and one of them or both of them have children from a prior relationship. And so the issue here is that there are competing concerns. These individuals typically want to take care of their current spouse. They also want to take care of their children. And so they can use a trust to balance these competing concerns. And so the Brady Bunch Family Trust here, this is an example of how someone might do that, right? So we've got the Brady Family Trust. Mike and Carol Brady are managing the trust during their lifetime. If something happens to them, they've got Alice, who's going to step in and manage the trust for them. Okay. And the idea here is that Mike has kids from a different relationship. Carol has kids. And so unlike the setup we saw before, where we said if one of them dies, everything goes to the survivor, right? Here, if someone dies, they may not want everything to go to the survivor, because then, if Mike is the one who passes away, Mike's kids might not end up getting anything. Everything would go to Carol. Carol may use it all up, or she may give it all to her kids. Relationships change over time. Typically, we're all happy right now when everyone's alive and well, but after someone's passing, that connection of how those kids were connected to the step parent is severed, and that can cause drifting and problems later down the road. How do we avoid that? Well, one way is to say on the passing of either Mike or Carol, money is split. So let's assume Mike is the first to pass. Okay. Then if Mike is the first to pass, all of Mike's assets go to himself, right? But Carol, who is deceased, her assets go over here to a trust that can't be changed. And Mike will use his own assets first. And if Mike needed extra money, he could potentially pull from Carol's assets, but only after he used his own money. And why do we do that? Well, Carol's assets, when Mike dies, are going to go to Carol's kids. Mike's assets, when he dies, are going to go to his own kids. So this is a way to pool the decedent's assets. So if it's Carol's assets sit here. They grow tax-free. They're available to Mike if he needs them. But if he doesn't need them, they're going to go down to her own kids. So here we've balanced, to some extent, the concerns of taking care of a surviving spouse and taking care of kids from a prior relationship. And as I've mentioned before, all of this is different. There are standards. It doesn't have to be that Mike has to use his own assets first before dipping into Carol's. It really depends on the family and the people making the trust and the financial abilities of each, and really getting a balance that makes sense for the surviving spouse and the children. Okay. And I'm going to move on, but just as an aside, anyone can feel free at any time. If I talk about an area that if I'm not hitting on something that applies to you, you can ask a question in the Q&A section, and I will have some time at the end that I will address those. You can also book an appointment with me just to go over facts that are more specific to your situation. I just populated a link where you can either exit out of it or click schedule here, put some time on my calendar, talk about something that fits more to you. You may not have kids, you may not be trying to provide for younger people. Happy to chat through your situation. Okay.